A commercial lease is essentially an agreement that's drafted between a landlord and a commercial tenant. The landlord is providing the space to the commercial tenant, and the commercial tenant can use that space, and they evidently pay for it, so it's an exchange for payment. The commercial lease process can be a short process, or it could be an extremely lengthy process. We've had a ton of different situations with our clients at the firm. So some of them, the negotiations will last like a month or maybe a couple weeks, and some of them will last 6 months, 7 months. So it really depends on the clients that we have. It depends on what they're leasing, where they are leasing, and also it obviously depends on who opposing counsel is as well, because that can change how many negotiations we have to do. The process in itself, though, no matter how long it is always composed of 2 steps. The first step is the LOI. That's your letter of intent. What that is that it's a very short document, sometimes a pager, sometimes just a couple pages, and it covers the most important elements of the lease. How much rent it is, where it's going to be located, what the square footage is. If it's a percentage rent lease, it'll usually say the percentage. The very important elements of the lease. You're not going to go through in detail in this. It's a very short letter. And then after that, what will happen is that the landlord will go ahead and prepare a lease based on the terms that were agreed upon in the LOI. And there you'll get your full lease. Here, again, it depends on where you're leasing. This could be an 8-page lease. It could be an 150-page lease. It really depends on what you're leasing and where you're leasing. Obviously, if you're leasing in a Cadillac Fairview, like a huge mall, or if you're leasing in a small shopping center, it's going to be a different type of lease in every single situation. What we're going to talk about today is I really want to run through some of the things that you always want to keep in mind before signing your lease. These are points that you always want to have top of mind. There are things that you want to consider and that you want to make sure are really properly negotiated and drafted in your lease. One of the most important elements of the lease, the most important, is that you need to know what the rent is. So how much rent are you paying and what are you actually paying rent for? This ultimately depends on the type of lease that you have. You could have a net lease, you could have a net lease, a net lease, or a percentage rent lease. Basically single net, double net, triple net, or percentage rent. All these nets are very complicated words to say that you're either paying base rent alone, or you're paying base rent with an operating cost, or base rent with an operating cost with taxes, or base rent with an operating cost with taxes with insurance, or you're paying percentage rent, which you will only see percentage rent leases if you're opening inside of a mall. Here, what the mall will be doing is that they will be taking a cut off of the amount of money that you're actually making. They get to take, for example, 7% or 8% of your gross revenue along with your rent, and maybe along with operating costs and taxes and insurance, which is usually the case. That's what you're paying for in general. Let's say you have a net lease. A double net lease, you're paying for your base rent with operating costs. The lease should state that you're paying this much base rent plus operating costs. If the lease doesn't state exactly what you're paying for, you need to clarify that with the landlord. It's really important. The idea is that if you were to pick up your lease, you should be able to sort of calculate exactly how much it's going to be. You won't know the exact amount because the operating costs will differ every single year. Your taxes might differ every single year. But you should be able to have a ballpark idea of what you're actually paying for and how much around it's going to be per month. This is the most important element. Like I said, you want to make sure the lease is very clear on this element. If it's not clear, don't sign the lease. That's my rule of thumb for you there. The second thing you want to make sure the lease is clear on is the length of the lease. The lease can either be indefinite in time, so it could go on forever until you decide to no longer rent there, or it could be definite. Usually it's definite. You're talking 3 years, 1 year, 7 years, depending on where you are. The lease should state how long it's going to be. My advice to all my clients is that if you're a startup and this is the first space that you're renting out and you have this really great new idea, don't go sign a super long 3-year lease. You don't know if your business idea is going to change. You don't know if in a year from now you're going to decide that, oh, I actually don't need a physical location anymore. So don't go ahead and sign a super long lease that you're going to be tied to and you're going to have to abide by. Try to be flexible in this regard. The next thing the lease should be super clear on is the space and the services that are provided. You should know exactly how much square footage you're getting. Go in and measure the space. It's really important. Figure out how much square footage you have. Make sure you're getting what you're paying rent for. That's really important. Are you getting any other common spaces with your lease? Is there like a common seating area inside this building, or the lobby part of the lease? Is the bathroom part of the lease? So all this should be indicated inside your lease. The other thing is you want to make sure the lease is clear as to what services the landlord is going to be providing to you. Are they going to be taking care of the garbage disposal? Who's going to be cutting the grass outside? Who's doing the landscaping? Is there security? The lease should state so. So if there are services and there are common spaces, it should indicate so in the lease. One of the things you want to make sure that you do before you sign your lease is always to make sure that you have a type of business that is allowed to operate on these premises. We have clients sometimes that come to see us, they've already signed their lease, and then they find out from the city that they actually can't have that type of business in that space, and now they have a lease that they signed. Don't ever do this. This is a very big mistake. The first thing you want to do is always call the city, ask them, tell them this is the type of business I have. Does the zoning law allow me to rent out in this space? There are some areas in the city where you can't have a spa, where you can't have a garage, where you can't have specific types of businesses. So make sure to check with them first before you sign a super long lease, or any lease for that matter. Another thing you always want to try to negotiate in your lease, and this one can be a bit difficult if you're dealing with a shopping center like a big mall, but you definitely still want to try to negotiate it, is exclusivity. What an exclusivity clause is that it essentially prohibits the landlord from renting out the space to any other person that has the same or similar type of business activity as you. Here's a really clear and good example. Let's say you are renting a space inside of a shopping center, and the shopping center has 6-7 tenants. You have a spa. Your spa offers manicures. It offers esthetician services. Next to you opens a hairdresser who also has inside of them a manicurist. This could be a problem for you because you could lose a client that may just go to the hairdresser and then get their nails done there instead. So what you want to do is you want to negotiate with the landlord and have them list out all the services that you provide and have it be so that it's prohibited for them to rent out to any other person that's also providing these services. Another thing that you could do is, let's say the landlord has several shopping centers in the same area. You could have it be that the exclusivity clause covers a certain radius of kilometers, so that there isn't one that's open a block away just because they own that center also. This is something that you can try to negotiate with the landlord, and I would really be stiff on this one if you really want to get a good lease in. Another thing that you always want to negotiate inside your lease are the lease repairs and improvements. The lease should be really clear on this point. Typically speaking, it should state what work the landlord is going to do before you take on the space, and then it should state what work you will be doing once you take on the space. The section regarding the landlord's work is really important. If you walk into the space and you see that this needs to be changed and this has to be fixed, write it down in your lease. The more clear you are, the better it is for you. Make sure to list out every single thing that you want the landlord to fix before you take on the space. The lease should also talk about how the repairs are going to be done once you take possession of the space. If you have a minor repair, usually it's the tenant that will take care of that. If it's something really major, like a structural repair, then it's usually the landlord that will take care of that. The lease should be very explicit on this point. Another thing is lease improvements. Usually when you take on the space, you're going to be improving the space. Let's say you're opening a bakery, and inside the space you're going to put in this huge granite countertop. Well, now this granite countertop is now part of the actual physical space, and it's hooked into it. It becomes part of the property. When you leave the space, who owns that after? Are you going to be getting payment for it? These are all things that should be considered inside the lease. Another thing that's really important to talk about in the lease is how the lease will be terminated, if it can be sublet, and if you can assign the space. A lot of people really skip over this part like it doesn't matter. This is probably one of the more important clauses, so I would really make sure it's done properly. You want to make sure that both parties can terminate the lease. You'll read a lot of leases, and a lot of them will only allow the landlord to terminate. Try to get it written in such a fashion that also the tenant can terminate the lease. So this is something that's really important for you. If you can't terminate the lease yourself, you should 100% be allowed to either sublet or assign the space. You need to always have some sort of exit strategy that allows you to leave the space if, for example, you change your business idea or you can't pay for the space anymore. There always needs to be an exit strategy for you. The last thing that's really, really, really important that you can do in Quebec is that you're allowed to publish your lease. Try to have a clause in there that says that you can publish your lease. Publishing your lease, what that does is that it informs the land title registry that you are renting out a space in this specific building. And what that does is that if the landlord were to sell this building to another individual, that individual can't kick you out because you registered your lease on the registry. This is really beneficial for you, so definitely try to get it done. Typically, when you'll get your lease, the landlord will state that you're not allowed to register it. Try to negotiate otherwise. These are a list of points that you should keep in mind when you're signing your next lease. Like I said, this is not an exhaustive end-all be-all list, but this is some of the more important things that you really want to make sure are well drafted in your lease. If ever you have any questions, if ever you want us to review your lease for you, help you draft your next lease, please don't hesitate to contact us. It would be our absolute pleasure to help you.